of the sports team. Now, very shortly, we'll be getting into our first conversation of the morning. Now, Chief Justice Gertrude Torkornoo has filed an application at the Supreme Court seeking to bar two justices, Gabriel Scott Pamang and Samuel Kwame Esiedu, from participating in the proceedings that could lead to her removal. Now, this follows allegations of an improper meeting between these justices and a lawyer for one of the petitioners, raising concerns about the integrity and impartiality of the inquiry process. Now, the Chief Justice is also seeking to halt all committee proceedings pending the final determination of her suit. We'll pause it for a very, very quick break. When we come back, we'll speak with two private legal practitioners to get a sense of where we are in this matter, what the potential next steps are, and also the broader and future implications. Don't go too far. We will be right back. This is still 3FM Sunrise on 3FM 92.7.
FM 92.7, Urban Lifestyle Radio Station.
Get ready, Ghana. The road is calling and the wheels are spinning. It's the 3FM Tour du Ghana happening Saturday, 7th June 2025. From the heart of Accra to the border town of Aplao, we are pedaling for the planet in a thrilling 192-kilometer ride across Ghana's scenic eastern corridor. Whether you're a seasoned cyclist or a passionate pedal pusher, this is your moment to shine. Form your teams, grab your helmet, and race for glory in Ghana's biggest cycling showdown. Challenge your limits, conquer the distance, ride for sustainability, be part of history. To register, call 0531 100 927 or 0532 200 927. 3FM Tour du Ghana, powered by 3FM.
Sunrise on 3FM. Shine with us.
Sunrise on 3FM 92.7.
With 3FM Sunrise.
And we are back. 19 after 8 is the time. This is still 3FM Sunrise on 3FM 92.7. Now, Chief Justice Gertrude Torkornoo has filed a suit at the Supreme Court fighting back her removal from office by President Mahama. Justice Torkornoo, in the suit filed on May 21st, 2025, sought a number of reliefs from the Apex Court. And we can take a look at the relief sought by Her Ladyship Justice Gertrude Arba Isaba Saki Torkornoo. And if you want full details, you can also check out 3news.com. And there's a story there that lists all the reliefs. But let's take a look. Now, a declaration that upon a true and proper interpretation of Articles 17.1 and 2, 19, 13 and 14, and Articles 1467 and 1468, Articles 2811 and 2951 of the Constitution, a Chief Justice has the right to a public hearing in proceedings before a committee appointed by the President to inquire into a petition presented for the removal of the Chief Justice. Okay, 2, a declaration that upon a true and proper interpretation of the same articles, the right of a Chief Justice to a public hearing and all the incidents of a fair hearing may only be excluded in the interest of public morality, public safety, or public order. A declaration that under the same articles, a Chief Justice who is called upon to participate in a hearing conducted by a committee constituted under Article 1466 to inquire into the merits of a petition seeking the removal from office of the Chief Justice can waive the privilege of in-camera proceedings. All right, Crosby, do us the honors. 4 up until the end, please.
So the fourth relief that Her Ladyship Justice Gertrude Torkornoo is seeking is that a declaration that under Articles 19, 13, and Articles 23, 146, and then 296 of the Constitution, a determination of a prima facie case in respect of a petition for a removal of a Chief Justice or Justice of the Superior Court is a quasi-judicial process requiring a judicious evaluation culminating in a reasoned decision. That's the fourth relief she's seeking. The fifth is this: a declaration that under the same articles, the purported prima facie finding in respect of the 3 petitions presented for the removal of the Chief Justice and served on the plaintiff by a letter dated 22nd April 2025 does not amount to a proper determination of a prima facie case and is therefore null, void, and of no effect. There's a sixth one, and this is it: a declaration that under the same articles, the purported finding by the President that a prima facie case has been made against the plaintiff and served on the President by a letter dated 22nd April 2025 was arbitrary, capricious, and in violation of the right of the plaintiff to a fair trial, and therefore unconstitutional, void, and of no effect. The seventh is this: a declaration that under the same articles of the Constitution, the purported determination by the President that a prima facie case has been established against the plaintiff as conveyed in the letter dated 22nd April 2025, together with the warrant of suspension of the plaintiff, constitutes an unjustified attempt to remove the plaintiff as head of Ghana's judiciary, and thus an undue infringement on the independence of the judiciary. This is the seventh one.
Eighth.
This is the eighth one. A declaration that under Articles 146, 6, and 7, the failure to serve the plaintiff with a judicious determination of a prima facie case before appointing a committee to purportedly inquire into the petitions for the removal of the plaintiff as Chief Justice constitutes, number one, a violation of the plaintiff's rights to substantive administrative justice and fair hearing, rendering the entire proceedings that has been initiated null and void. This is the eighth relief she's seeking. The ninth is this: an order setting aside the warrant for suspension issued by the President dated 22nd April 2025 to suspend the plaintiff as Chief Justice of the Republic. The 10th relief that Her Ladyship Justice Gertrude Torkornoo,
and this is 10 of 16. There's 16 reliefs in total.
Right.
So.
The 10th is this: a declaration that under the same articles we're talking about of the Constitution, the second defendant, Justice Gabriel Scott Poamai, is not qualified to be a chairman or member of the committee set up by the President to inquire into the petitions against the plaintiff on account of having adjudicated and giving various rulings in favor of one of the petitioners, Daniel Ofori, in actions filed in the Supreme Court. 11th is this: an order prohibiting the second defendant, we've spoken about that already, from presiding as chairman or participating in the committee's proceedings. The 12th, a declaration under the articles we've spoken about that the appointment of the third defendant, and his name is Justice Samuel Kwame Adibu Asiedu, as a member of the committee at a time he had already sat on a panel of the Supreme Court constituted under Article 1282 to hear an application for interlocutory injunction by a Ghanaian citizen challenging the Article 146 proceedings against the plaintiff violates the independence of the judiciary. The 13th, relief, an order prohibiting the third defendant from sitting as a member or participating in the proceedings. The 14th, a declaration that under the articles we've mentioned and 4 of the Oaths Act 1972, the 4th, 5th, and 6th defendants are not qualified to undertake the functions entrusted on them as members of the committee set up to inquire into the petitions. And then the 15th, an order restraining the committee set up by the president to inquire into the 3 petitions composed of the 2nd, 3rd, 4th, 5th, and 6th defendants from proceeding to carry out their terms of reference. And the last relief that the suspended justice is talking about is that a declaration that under Articles 146 and also the 4 of the Oaths Act 1972, the 4th, 5th, and 6th defendants are not qualified to undertake the functions entrusted on them as members of the committee set up to inquire into the petitions.
All right, I think the final one is any other orders as this honorable court may deem fit. Okay, that's what I'm reading on our 3news.com portal. Do check it out. The full details are there if you want a recap of all the reliefs sought by Her Ladyship Gertrude Torkornoo on this matter. So a number of reliefs sought. We've discussed a few of this during our news review segment, but we can also speak with lawyer Christian Malm Hesse is a private legal practitioner. Counsel, hello, good morning.
Good morning, Helen. Good morning to you.
Hope you're doing well.
I'm fine.
Thank you so much for joining us on the program. We've just been discussing the issue of the Chief Justice's suspension and the latest updates, and that is in relation to Her Ladyship filing a suit at the Supreme Court, fighting back her removal from office by President Mahama. There are a number of reliefs that she's seeking, 16 of them, and we've just run through that list. But I want to start off on this point. What are the legal standards for recusal or disqualification of judges or committee members in proceedings involving allegations of bias or conflict of interest, especially in the context of Article 146 of the Constitution?
Yeah, I mean, basically, when Article 146 has been espoused for some time, Article 146 in the Frank Chum of the Attorney General, Lateba GSC indicated that there exists no clear procedures when it comes to the removal of the CJ, and admonished that the Rules Committee should endeavor to strengthen that part of the law as far as establishing a standard rule of procedure to be engaged. But as we have it, there exists none. And the important thing is that when it comes to situations of likelihood of bias, it falls into the general principles of law and on natural justice, so that if there is a likelihood of bias on the constitution of a panel. That is to hear your matter. You have every reason to mention that out. I remember on Mr. Okansi's program on Saturday, one of them had mentioned that the constitution of the panel, I even mentioned Mr. Domlevo and yes, because if in the past, let's say with you, I've had issues with you, or you have had issues with me, and I come to sit in front of you to determine my destiny. I mean, how honest are you going to wield the sword of justice on me? It becomes very easy. We are human beings, and by that fact, or by that occurrence, that's the right word, by that occurrence, it creates what we call an idiosyncrasy in the mind of that particular person. So, like the analogy that I use between the two of us, that idiosyncrasy is created in there. And as human beings, if you branch into psychology, we have our perceptive values. And these perceptive values influence our reality. The reality that we conceive as reality is influenced by this perceptive value. And the perceptive value sits in our values. Now, so if you just oppose it to everything, it goes into what the Chief Justice is doing, that, well, I am not against the process. I am not against the panel in principle, but I have a number of issues which I want them to be addressed. And it is legitimate for her to raise those concerns for the Supreme Court to determine whether those concerns can be upheld or could be dismissed. It is for the Supreme Court to determine.
Now, there's also the request for a public hearing. What is the significance of the Chief Justice's request then for this public hearing, and under what circumstances could she be granted this wish?
This one too, I mean, it comes under Article 146, which decided authorities, include the one I mentioned, talks about in-camera hearing. Now, when we go into the constitutional interpretation of that, and we look at the objective and then subjective values in the interpretation of that, it is to protect the image of the very person, the justice. Now, in the situation where the Chief Justice is saying that I am to be protected, I want to waive that. What do you do to that? Is it legitimate? Is it not legitimate? But this is the rationale, because with every constitutional provision, we have in every constitutional provision and the interpretation of that constitutional provision, we look at the purposive interpretation of it. And in looking at the purposive interpretation, we look at the objective and the subjective. The objective test deals with what the framers of the Constitution envisaged. And then the subjective test deals with the legal antecedents, historical values, and the changing times as far as the people of that particular country is concerned. Now, so a constitutional expert or the court combines both the objective and the subjective and comes to a conclusion. Now, if that conclusion will be incorrigible, unconscionable, or absurd, it will choose the latter. Now, juxtaposing it to this, if the Chief Justice is of the opinion that I want to waive my right because the framers of the Constitution envisage that my reputation, that's the whole essence of the in-camera hearing, so that in the situation where the Chief Justice is not found culpable, her image is intact. And so if she's not found, all that processes that we would say went on would have been in camera and not for the digest of the public. All we will know is that some recommendations are out and it's vilifies her or not. But at the end of the day, the person says that I want to waive it. It's just like a matter being heard at the Supreme Court, and an application is made by the learned Attorney General that I know that the rules of court does not permit this, but I would want a live broadcast, like the election petition. I would want a live broadcast of this. And the judges would go into their conclave and they say that, okay, all right, even though the rules of procedure is against that, let us allow the cameras to come into court and see how this is done. So it is one of waiving rights. Let's allow the Supreme Court to determine whether in such a situation where it affects the person can waive her rights in the situation that we find it. It's a beautiful movie.
Lawyer, you say it's a beautiful movie. You're excited to see what the outcome of this is going to be. And I think many Ghanaians are also waiting on tenterhooks to find out whether or not this waiver will be granted.
I'm sure she just wants Ghanaians to see, I don't want to say this, but see Ghanaians to see how she's being handled.
Okay.
Yes.
So that you say that maybe in her thinking, Ghanaians can then be their own judges as they watch the proceedings unfold for themselves.
Yes.
All right.
So that the cross-examination, you see, so there'll be a whole hearing. So a hearing is a trial. So,
right.
Based on the three petitions, Ghanaians would get to know whether the petition is credible, a prima facie was laid, is anything to hold, this is all that was mounted against me. If so be it, if it hooks up in law, let me be slaughtered. And if it doesn't, Ghanaians should see it for themselves and they judge it for themselves. But like I said, it will be for the Supreme Court to determine whether such rights, if the person calls for it to be waived, can be. It is for the Supreme Court to determine that.
And I want to... sure.
Yes. Please come in.
Thank you, Counsel. I wanted to also look at Relief 9. And time check, it is some 22 minutes to the top of the hour, 9 a.m. We're speaking with Lawyer Christian Mamhesi about the suit as filed by Her Ladyship Justice Torkornoo. Now, Relief 9, Counsel says that Her Ladyship is seeking an order setting aside the warrant for suspension issued by the President dated 22nd April 2025 to suspend the plaintiff as Chief Justice of the Republic. I want to find out if there's a constitutional or legal basis for suspending the operation of the presidential warrant for the CJ suspension until the Supreme Court rules on her application.
Okay. With that one to, is it that one to Article 14610? That one to, it is a discretion exercised. As to whether that discretion was exercised under Article 296, capriciously and all of that, it is also for the Supreme Court to determine. It is one of discretionary power. It is only the court that could indicate whether the exercise of that was capricious or not. And if the court holds that the president did no wrong, it still sticks. If the Supreme Court comes to a conclusion that the president ought not to have suspended the CJ, but while the CJ remains in office, these hearings could proceed, is also another decision for the Supreme Court to decide. Whether or not, if CJ is in office, she could interfere with the hearing, is another point altogether. Whether she could affect the outcome of the hearing is another point of consideration. Whether indeed she could or not. Whether she would have a hand in the presidential committee or not. I am of the belief that it is not possible for her to have a hand in it because the constitution of that committee, that constitutional mandate, is not derivative of hers. It's not part of the courts that the CJ is mandated to constitute, from the lower courts to the high courts in Ghana. So her influencing that, because let's see it as this, it is more like an interdiction, you see, under the labor laws. That's the side, so that you step aside for us to do all the affairs of the employment relationship, or as far as the company is concerned. But this is a situation where so that's why I'm using the phrase whether or not. It would be for the court to consider whether or not she would have any form of interference in that presidential committee formed under Article 1466. If indeed she will, the Supreme Court will come to a certain conclusion. If indeed she wouldn't, the Supreme Court will come to a certain conclusion. But that decision would be analyzed in the light of Article 296, which deals with discretionary power.
Counsel.
Yes.
Now let me take you to another aspect of this suit. There's been an alleged meeting. It's alleged that certain justices on the committee have been seen or cited with counsel for one of the petitioners. Does that constitute sufficient grounds, would you say, for their disqualification from the committee? Are there any precedents or legal principles to support this? It's become the center of some controversy as we speak.
You said there's been allegation that
allegations.
Some of the justices on the presidential committee
Indeed.
were seen with some of the lawyers of the petitioners.
Indeed.
So, I mean, if that is true, then it's really conflict of interest. I mean, if that is true. And it must also be founded in evidence as to the nature of that meetup. So let's say a judge closes from court and walks into his car. He meets a party who has a case in his court. And maybe they wave at each other. Oh, my lord, and you bow to the person. Is that enough to say that the judge is compromised? So it is just not it, but it is one of facts. And that fact will be construed into evidence. So definitely, as they go to court, they are best persons to describe or to put across the evidence that they have in citing it. They are just the reliefs, but when they get into court, the arguments would come out, the evidence would come out, and we will know exactly what they meant by they have been cited and all that. They'll go into detail and provide further particulars about that. That would inform the mind of the court to have the said disqualifications done.
Now, what mechanisms exist within the judiciary to address and investigate allegations of misconduct by judges involved in sensitive proceedings?
Oh, judges have their own code of procedure. Judges have their own, just like lawyers. We also have our ally under Act 32. So, and which deals with us when we misconduct ourselves, we go to General Legal Counsel and all of that. Judges also have their own code of conduct that upon any stated misbehavior, they also go through similar procedures. So once it's a closed profession, there are laid down procedures on how members should conduct themselves. So in a situation as that, the law takes a course.
What legal remedies are available to the CJ if an application is dismissed by the Supreme Court? Are there any further avenues for an appeal, maybe a review?
Oh, I mean, for a review to happen, there must be what we call exceptional circumstances. That would mean that a full bench is empaneled. So should her reliefs, I believe that maybe some of the reliefs will be granted, and in the probable circumstances, all of them could be granted, or none of them could be granted. I mean, that is the probability of life. That you could have all your reliefs granted, you could have it granted in part, or you could have all dismissed. So we wait to see how all these three probabilities would pan out.
Absolutely. And finally, counsel, if the committee is found to be improperly constituted or tainted by bias, what would be the appropriate legal remedy? Dissolution, reconstitution, or something else?
Rightly so. You just nipped it in the bud. If it is declared as that by the Supreme Court, then the president, working together with the Council of State, they would have to reconstitute the panel or the committee again, and so that they can start their work. You know, it is with this that what do you call him? Justice Dateban indicated in that erudite judgment that the Council of State needs an expert to assist them in functioning, in coming out with all of these. I mean, but the law remains unamended to have such functionalities available to the Council of State. Because in such situations, once the committee is tainted by party colors, it becomes difficult for it to function. I'm talking about the committee.
Right.
It's tainted either by party colors or by likelihood of bias. It becomes what it is. The natural justice requires that you just cannot have such a person sit to administer justice to you. Let's see how all of this will pan out at the Supreme Court.
Absolutely. We will be waiting to see how all of this pans out at the Supreme Court. Counsel, thank you so much for your time and always lending your expert view on these issues. Do have a wonderful Thursday.
Thank you so much, and thanks for having me.
Again, that was lawyer Christian Mamhesi. He's a private legal practitioner, putting some more flesh on the bones for us. And he says it's going to be a a wonderful movie. That's how he describes it. We're all waiting to see what the final results will be at the Supreme Court. Her Ladyship is seeking some 16 reliefs. Will all be granted, some be granted, none be granted. Of course, we will be here to ensure that you are following along with the process every single step of the way, and that's throughout all our programming right here on 3FM 92.7. We'll go on a quick break. When we come back, there's a matter that's dear to us, dear to our hearts. Noble Crosby Annan will be taking over the reins, and we're talking about the health risks of modern lying in state practices. I'm sure many of us have seen videos circulate, and some have gone viral, about the way in which we handle the dead. I've seen a number of interesting practices in modern times that causes us some concern. So gather around, tell a friend to tell a friend. We're having a very important conversation this morning right here on 3FM 92.7. Don't go too far.
3FM Sunrise.